Hi, I'm Rob Carolina. This is one part of a multi-part introduction to the Law and Regulation Knowledge Area of CyBOK. The Law and Regulation Knowledge Area is one of 19 knowledge areas in the entire project. The webinar that introduces this knowledge area is pretty long, and so I decided to break it up into 15 constituent parts. You are now about to listen to one of those parts. If you haven't already done so, I would recommend that you go back and listen to the introduction. It's also labeled Part 0. That'll help you understand what's about to happen. Alternatively, you can listen to the entire webinar as a single file. So without further ado, let's listen to this part. I want to turn our attention to the problem of dematerialization of documents and electronic trust services. Once upon a time, we had lots of experience with documents. We had vellum, paper, signatures, seals, fingerprints, witnesses. We had centuries of experience in developing forensic techniques for the purpose of detecting forgery. Then came dematerialization. Documents and messages move into an entirely electronic format. This had the effect of destabilizing our understanding as a society of how to test authenticity and integrity of documents. There were two very different responses to this. The first came with the original EDI networks, and that is, well, let's stick a trusted intermediary in the middle of a trading network. That way, we will have an organization who is neutral, and they will act like an umpire or a referee, and they will keep a copy of all messages, and if anything goes wrong, they will hold the authoritative record of what was said and when. That's how we will guarantee authenticity of the message, because that central party will have its own security procedures, and how we will guarantee integrity of messages, because that central party will keep a certified copy of those messages. EDI networks have been around for half a century, and they are still very successful. They're very expensive to set up, but they can work very efficiently. If you have any questions about that, all you have to do is look at things like airline reservation systems or SWIFT, the International Funds Transfer Network. As technology moved along, though, people started looking for different types of solutions that were easier to adopt or more widespread. And as computing technology became ubiquitous, as everybody got a general-purpose computer that had quite a lot of processing power, and as telecommunications networks became more accessible, bandwidth became accessible, people started to communicate with each other over networks. A wide array of security solutions, technological solutions, came into the market with the promise that we have a solution that will help guarantee authenticity of messages and integrity of messages. A lot of those technologies, I would say most of those technologies, were based on some type of public key infrastructure, although you could argue that some of the technologies are really founded on symmetric key. I don't want to get into that discussion right now. Once those solutions came into the market, people began to realize there were a series of legal challenges that had to be overcome. And I've identified 4 of the basics right here. The first, can we admit into evidence this electronic document, this electronic message? Will courts be prepared to read it? In the early days of computing, this was viewed as a major problem because courts had difficulties knowing whether or not they could or should trust digital evidence. But by the time we'd gotten to the 1980s and early 1990s, many courts around the world had become comfortable with this idea, and there were sort of a few holdouts in developed countries, but this problem started to move away. Secondly, requirements of form. Many times, a communication, in order to be legally effective, must follow some prescribed form. Not all the time, but when these problems come up, they are quite severe. So some types of contracts to be enforceable must be in writing. Some types of contract clauses to be enforceable must be presented in certain types of lettering, or this is how the law was written at the time. Similarly, some types of communications must be witnessed or must be signed. And so that gets us into the problem, as you see in the next area, electronic signature. How do we know that an electronic signature will be given equal treatment at law with a handwritten signature? And fourth, the problem generally of identity trust services, the problem here is liability. How can we rationalize the liability of people who are providing trust services, because trust services are a core feature of public key infrastructure? How do we get a certificate to bind the identity of a signatory? Well, you have a certificate. Well, who issues the certificate? Suddenly we're into this problem of what kind of liability could a certificate issuer face? When you bundle all of these problems together, what you got were a wide variety of laws adopted all around the world, and they're called various things: digital signature laws, electronic document laws. They have a blinding array of titles, and if you want to read a lot about these and get right down to grips with it, I can think of no finer source than the work of Stephen Mason, which I cite in one of the endnotes in particular. He's cited a couple of times in CyBOK, but his work on trying to collect and describe these various digital signature laws around the world, I think, is really unparalleled. Now I want to take a moment